Tonight and tonight's story, it's more bad. It's bad stuff. It's tonight and every night is bad, bad, bad.
We will go on the record in the matter 24 CM 202, State of Wisconsin versus Andrew Cote. The state appears through Assistant District Attorney Holly Rockow in person. Mr. Cote appears in person in custody with counsel Joel Faliski. We're set today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Faliski, can you please recite the agreement for the record?
Yes, Your Honor. Mr. Cote has agreed to plead to one count of misdemeanor disorderly conduct with the remaining counts in the complaint dismissed and read in, and a joint recommendation by both parties for court costs totaling $443.
And I believe he was in the process of a revocation. Was he revoked or did?
Yes, Your Honor. As of yesterday afternoon, the final decision from the administrator came in and he has been revoked and he will be sent to Polk County for sentencing.
Okay. And what charges was he convicted of in Polk County?
I believe they were substance use related, Your Honor. I was not originally opted into that case. That was my predecessor, Mr. Pollack. Unfortunately, I cannot speak to any detail as to the nature of those charges.
All right, thank you. I can just pull it up. I just am curious.
All right, good morning, good morning, good morning. I don't know how in the heck Kathy does it. I don't know how she does it. I gotta give her all the credit in the world. Fozzie, thank you for mentioning it. I was walking around the house a little bit ago and I was actually thinking about it and I was like, nah, I don't have it in me to do it, but if Kathy can do it, we can do it in her honor. So good morning, everybody. There's a lot more of you guys up than I thought would be this early. I thought Fozzie was the only one in the world that's up this early. Even the Vampire Alley's up, so go figure that up. Good morning, Shed In, and is it Lisette? Lisette, we'll say hi to Lisette. And Twitchy, and Emily, and Fozzie, and same. This Judge Mogan, this is a funny one. I like how she's kind of a smart ass with him. She doesn't let him play games with her, so let's go and see what she does here.
Would be for the 24 cases or for a 21 case, Mr. Cote?
24.
Oh, 24 case. Okay, so for the 24 cases, possession of amphetamine as a repeater, possession of cocaine, a misdemeanor. What it looks like. All right. Okay. Basis for the agreement and why it's in the public interest, Ms. Rockow?
Your Honor, Mr. Schmidt negotiated this case with Mr. Pollack and Mr. Flasky, but based on my review of the file, I believe that this was based upon the facts and circumstance surrounding the case being relatively minor in terms of the disorderly conduct. There was, of course, the violation of the bail, but that was the Polk County bail. And so it looks like that was all resolved with his latest revocation. So those bail jumps being dismissed and read in is appropriate for that reason. And I don't believe that any additional confinement or supervision is going to be necessary as he is facing that sentence for the revocation.
Okay. All right. So we do have victim SB in the courtroom here today, and Ms. Bauer, SB would like to make a statement. Is that correct?
Yes, Your Honor.
SB may come up here and have a seat at the black desk and you may provide a statement. If you are going to read something, please read it very slowly so my court reporter can take everything down.
Of course. I was in a relationship with Andrew Cothey for almost a year. Since we started dating on January 22nd, 2024, I knew there was something wrong with the way he would talk to me or even act. But I was in love. On April 5th, that's when the real anger started. Almost every day from then until the 22nd of October, or the 21st of October, there were fights. He would hit me, but he always thought that he could just make it up. Sorry. On October 21st, we were at a friend's house and he was on the phone with a friend. And just out of nowhere, he called me the B word and then threw a car manual at me. Seconds later, he would spit in my face. But once again, made it up, told me he would never do it again. But just a couple hours later, my world flipped around. On October 22nd, about midnight, we left the friend's house and he drove to a parking area in Grantsburg. I ended up falling asleep in the passenger seat, like I always had. He ended up waking me up to ask me where the drugs were. I handed him what he had wanted. And I went back to sleep. He woke me up again and asked me for the other bag. I said I gave him everything I had and I didn't have anything else. He got angry and started firing the flare gun out the sunroof. The second time he woke me up, he asked me once again. And I told him the same thing I had told him the first time. This time, he got mad at what I had told him, and he ripped off the rearview mirror and threw it in the back seat. Then he took the passenger visor and ripped it off the car, and then hit me in the cheek with it. The third time he asked, I told him the same thing. This time, he ripped off my glasses, bent them, and broke them. So I thought I was going to try and call for help. He ended up taking my phone and with his two hands, literally ripped it in half. The fourth time he woke me up, I kept repeating what I had told him every time. And this time I looked at him and I looked in his eyes and they were black. It was like Andy was gone and someone else took over. The next thing I knew, he started bashing my head against the passenger window. And all I kept thinking was, I have to get away, otherwise he's going to kill me. So I had got him calmed down enough to where he would drive to Dollar General where the van was parked. We were going to move it, but we decided he didn't want to because he was getting tired. He let me drive the car, and I knew that was the only way I was going to get out. I drove the car to the Frederick Trailer Park, where I knew I would be safe. I parked in the front entrance and stopped. He woke up and started yelling, calling me every name in the book, but I was only able to grab my purse, and that was it. I started walking to my friend Jen's house in the park, and I got there and she asked me if she could call, and I said yes, and fell to the ground. The cop from town came and my body started going numb. I ended up throwing up and passing out. Not knowing what was going on, they called the EMTs, and I went to the hospital and had a CT scan. Your Honor, this is still painful for me. I have anxiety and panic attacks now. every day. I am actually on nightmare medicine. I don't know the name of it. But I have nightmares every night, every time I sleep, of what he did to me. I am in therapy almost either 1 or 2 days a week, and I will be on therapy for at least 3 years, she said. This was 6 months ago, and yet it still gets to me every day. I don't know how I'm going to move on from this. So I'm asking you for some stipulations. 90 days in jail, no contact with me, my property, or my roommates, no possession of firearms, anger and drug treatment, and probation. I don't think it's fair that I have to live with this every day and he would get away scot-free. He has made it to where I don't feel safe, and I will be putting 2 restraining orders on him for both counties. I can't go outside by myself. I can't go to the store by myself. He's already threatened me enough. Thank you.
Thank you. Just a bit of information. You only need 1 restraining order. It covers you everywhere.
Okay,
So you
Thank
don't
you.
need to go to both counties. Thank you for your statement.
thank you.
And just to throw in a little bit of information, restraining orders work everywhere also. I know somebody who had an Ohio restraining order and it was being enforced in Florida. So I'm not, it seems like that would be in everywhere. I don't know if each state has to do reciprocal. I don't know if it's like concealed carry license and all. But no, it's no, Darren, I don't. No, it shouldn't be dark in the morning. But I'm doing this out of memory of Kathy. So we'll do that. Let's see how Judge Mogan deals with this guy.
And for the record, and I'm sure that, well, maybe the state had more information, but that's not any of the information that is contained in the criminal complaint. The criminal complaint is very sparse and just indicates that there was an argument and it may have escalated, but what I have access to doesn't discuss the level of what that argument may have been or consisted of. So, all right, so then the agreement, Ms. Rockow, now again, after hearing the victim, what is the basis for the agreement in the justice or in the public interest?
Well, Your Honor, I think some of that information wasn't information that the state had when this case was charged or when this offer was made. It's not my file, but from my review, I didn't happen upon that, what was described just now. So based on the facts that are contained in the criminal complaint.
And again, and I'll state, you're probably hearing or seeing it for the first time as the court is, because the criminal complaint is one small little paragraph that just describes a fight that occurred and that it may have escalated a little, but none of the detail.
Right. But Your Honor, again, Mr. Cothey has been revoked in Polk County on some more serious charges and is going to be presumably serving a jail sentence. I think at least one of those had some stayed jail time. So I think that he's going to remain in custody for a while. I don't believe that based upon the facts that anything more is necessary here. I think that the bail jumps again were associated with the Polk County cases. So I don't consider that to be, of course, he violated his bond. But I think that the focus here in Burnett County should be the disorderly conducts. And I don't think that any jail or probation is appropriate. I do think that costs only is sufficient to protect the community.
All right, and my guess is that the state wasn't aware of, I'm gonna guess also maybe the police were not aware of the extent of the argument or what occurred that night, because otherwise I'm questioning why a battery wasn't charged.
Right. I don't have any information about bruising or pain or injury in the file as I review this.
All right, okay. And he is being revoked, and I'm taking judicial notice of 24 CF 15, 24 CF 224, and 24 CF 310 Polk County matters, in which he has now been revoked on those matters and will go face sentencing in Polk County. I believe in those cases, there is no state jail time. That was that fictitious thing that some judges do, and they fictitiously say, I'm having that fictitious conditional jail for probation to use if they wish to do.
Understood.
And so with regards to the charges in Polk, he does have the possession of amphetamine with the repeater. So that means the maximum possible penalty of 1 year he could face, with the increase of no more than 2 years for that underlying misdemeanor in Polk County. But that's for Polk County to deal with and for you to deal with in Polk County. And you were under bond conditions in Polk County when you violated your bond here by engaging in the criminal actions here in Burnett County. And for the record, and this is, I guess, for the victim as well as you, Mr. Cote, for you to be aware of, and perhaps the reason why these were simply charged as disorderly conduct is because of the little bit of information that was provided the day of the incident, at least that I have in front of me. And usually what's in the criminal complaint is what is been provided to the police in the police report. So there's not much. This is the first time that I believe perhaps even the state is hearing the depth of what may have occurred that night. So he's pleading guilty to one count of disorderly conduct, is that correct? And the other count will be dismissed and read in, and he's facing the other charges in the bail jumps in Polk County?
To my understanding, Your Honor, that is correct. It's a plea for one count of disorderly conduct, with the remaining counts in the complaint to be dismissed and read in. As has been stated, he has been revoked from probation, and he will be sent to Polk County for sentencing after revocation. I would like to take note that he has been in custody on this revocation hold stemming from this incident since October 31st of 2024. He has accumulated approximately 155 days of jail credit. The conduct has again prompted revocation here, in the maximum sentence for a charge of disorderly conduct has been vastly exceeded. It's He's sat for close to double the amount of time he would for the maximum sentence on this. The public, I believe, has been sufficiently protected. He will continue to reside in custody, awaiting sentencing after revocation. I believe he will be returning to active supervision for his Polk County charges as well. In entering this plea, he is taking accountability for this and does wish to move on. For those reasons, I would ask the court to adopt the joint recommendation. Thank you.
All right, can I have the plea questionnaire waiver of rights form, please?
Yes, Your Honor. May I approach?
You may. So I have in front of me the plea questionnaire waiver of rights form. Mr. Coakley, did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he go over it word for word?
Yes, Your Honor.
And do you understand it completely?
Yes, Your Honor.
If you didn't understand it, did you ask him to explain it?
Yes.
And he did so?
Yes, Your Honor.
So you're 37 years old, you have 12 years of schooling, you can read, write, you understand the English language.
Yes, Your Honor.
That's your signature on the second page.
Yes, Your Honor.
You're pleading guilty to 1 count of disorderly conduct, is that correct?
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
No mental illness or disorder and no alcohol, medications, or drugs?
No, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over these rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, Your Honor.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand the state would have to prove on or around October 21st, 2024 in Burnett County, Wisconsin, while in a private place you engaged in indecent, boisterous, abusive, and otherwise disorderly conduct, which under the circumstances did tend to provoke a disturbance. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty? The maximum possible penalty of this crime could be a fine of up to $1,000 or up to 90 days of incarceration or both. Do you understand that?
Yes, Your Honor.
Do you also understand I have a recommendation from both of the councils, both of the attorneys here, a joint recommendation for costs only, that would be court costs and DNA surcharge, etc. Costs only for $443. Do you understand that is simply a recommendation to the court?
Yes, Your Honor.
Said differently, that means I'm not bound to follow that, and I could sentence you all the way up to the maximum possible penalty, and I could do that here today if I thought it was necessary and warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, Your Honor.
And again, that's that document that basically says what happened that day and why you were charged with the crime. And albeit it is very short and it doesn't have a lot of facts and it doesn't have as many statements or factual assertions as the victim did state here today, but as it's stated in the probable cause section of that criminal complaint, for the most part, are those facts accurate?
Yes, Your Honor.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I just know that when she dropped me off, she was yelling stuff at me when I drove off.
So what did you do?
I just drove off.
You didn't do anything?
Oh,
You didn't provoke a disturbance?
no.
Good, we're going to trial. Thanks. We'll set this matter for a trial. Okay? Sounds like we're gonna have a trial on 2 disorderly conducts and 2 bail jumps. That sounds good to me. So maximum possible penalty for 2 disorderly conducts, up to 90 days of incarceration, and for 2 bail jumps, up to 9 months each. Because if you're indicating you didn't do it and you're indicating that you're innocent, by golly, the state has to prove beyond a reasonable doubt. And so I think we're going to set the matter for trial, and I think we need 1 day. Let's set it for trial here today, Miss Rockow. Is this going to be a York case or is this going to be a Mr. Schmidt case?
This is Mr. Schmidt's case.
Okay, let's get the matter set for trial and we can do it. I can presume you're gonna be in custody for a while, since you are revoked on, your Polk County matters. But we don't have a problem getting you back here for a trial. We have a really great, lieutenant who runs our jail very well. And we have the ability to, do transport. So let's get this matter set and let's get it set for sometime soon. And we have the victim here so we can make sure that we have a date that works for the victim as well. How about June 24th? It is on the Assistance Week, but June 24th sounds like a good day to have a trial. How does that work for you, Mr. Feliski?
I'm available that day, Your Honor.
Excellent. So we'll have a trial on June 24th. That'll be a trial because again, if you didn't do anything that day, that's what your assertion is here, Mr. Colte. The state has to prove it beyond a reasonable doubt that you engaged in any type of conduct that would be disorderly. And whether or not you were on a bond in Polk County and whether or not you violated that bond and you did so knowingly. So that's what we're going to do. June 24th, we will have a trial. We only need one day. That works for victim, Ms. Bauer? Yes, sir. Excellent. Now let's get to my final drop dead date. That means, Mr. Colte, that is the day that I will no longer take any type of agreement, okay? I won't accept any agreement in this case, all right? And so that means the matter will go to trial and you will be able to have your attorney state or actually have it'll be the state trying to prove the case and your attorney will be able to defend you and your claims at this matter. But on May 29th, that'll be the last day, the drop dead date for any agreement that'll be reached. And quite honestly, to me, the court does not find a disorderly conduct with costs only, especially hearing the statement from the victim to be in the public interest. So let's do May 29th, Mr. Feliski, May 29th. Well, you said that this is going to be a Schmidt, even though it's on that. So let's do May 19th, drop dead date. May 19th, can you do 10:45?
Yes, Your Honor.
All right, May 19th at 10:45, we're going to have our drop dead date for any agreement that can be reached in this matter. Otherwise, we will go to trial. We don't have to worry about lab. We have confirmation that victim will be able to be present and here for the trial. We're good to go. All right. Thank you. We're adjourned. We'll see you then.
Thanks, Your Honor.
Many people struggle with the meaning of.
All right. Hey, Kathy, how are you? I don't know how you think this early. My brain is literally not connecting some things. Absolutely, we're live. Kathy's working a double, and so we thought we would give her a chance to take a break and we'd do a live. But surely enough, we're here. We've got a couple little court cases. I've been trying to work out some commercials, and this lady here popped up on my feed, and to me she's funny as could be. So I'm through there. Thank you, Kathy, for the gifted memberships. That's awesome. Thank you. Let's hit play on this and then go on to the next one, which is going to be great. It's going to be the best video ever.
Many people struggle with the meaning of this common English word. So for the sake of clarity, here's a few examples of what no doesn't mean. Yes. Ask me again. Don't listen to me, and just do it anyway. Now let's test your knowledge. I'm going to say no to you, and I'll wait for your response. No. Did you get that? The correct answer was, okay.
Your Honor, I do have an announcement for Mr. Bowie.
Ready.
Judge, this is, I have Mr. Bowie here next to me, Judge. So Mr. Bowie does wish to enter a not guilty plea today, although he also wishes to ask the court to set a bond on his case. He is held on this misdemeanor offense with no bond. My understanding is that at the time, the magistrate court did not issue a bond because he was on probation. However, he is no longer a probationer. I've discussed this with Ms. Hagler, so I believe that she's aware that he is no longer a probationer. Additionally, Judge, the alleged victim in this case is on the Zoom call. So the alleged victim will have which is his son, is logged on as iPhone Bless. So Judge, we would just ask that the court go ahead and set a reasonable bond on Mr. Bowie's case because he is entitled to a bond on his misdemeanor offense, Judge. And he has been incarcerated since March 6th, my understanding.
And Your Honor, the state would object. The defense counsel has not filed a motion to modify his client's bond. We have not been put on appropriate notice. And so the state is not ready to argue for any type of bond. Is not ready for this bond hearing today. So we just ask that the defense counsel will file this motion that way the state can be placed on proper notice and make the proper arguments.
And Your Honor, you're muted. Judge Hayward, you're muted, I believe.
Okay.
Can I respond or did you want to go ahead?
Respond.
Judge, so I think that based on the fact that if he's not a probationer, he's entitled to a bond on a misdemeanor offense. The alleged victim is here. I believe it's well within the powers of the court to set a bond for him today. And I believe in the interest of judicial efficiency, there's no, and I don't, I understand she wants me to have to file a motion so that there'll be more time where my client has to sit in jail. But I think we're here today with all the parties. And I would ask that, the court set a bond on his case. And his son is asking to be heard as well through chat.
Your Honor, at this time, again, the state is not ready to proceed on a bond hearing. So
all right, let me ask this. Does he have a history of violent offenses?
My understanding is no, Judge.
Well, he does have, I did see a few probation violations. That was just from the Cobb County one in 2023. I do see that he has a New York history as well.
I want to know about that. I want to know if in Georgia, in the recent past, last 5 years, does he have any violent history?
A fleeing attempting. That was 2023. And that's pretty, that would be the most recent in Georgia. But again, he does have out-of-state history, Your Honor.
Okay, he has no bond on any of the 4 offenses?
Correct. And Judge, I don't.
And Your Honor,
No, I'm sorry.
I was just
stop. Everybody stop. Hold on. First of all, I got a witness texted, chatting, saying he was told he would be allowed to speak. Well, that's only if we have a bond hearing. I'm not sure I'm having one. I'm asking questions right now. Number one. Number two, who's the alleged victim in this case?
That would be his son.
Okay, the person who wants to talk to me?
Yes, Ms. Bless Bowie. I believe that's.
Your Honor, I would just ask for a moment to be able to speak to the witness. As it has been stated before, counsel doesn't represent the victim or any witnesses in this case. His best interest is his client. I think it's inappropriate for counsel to make statements on behalf of the victim in this case. I don't know what conversations that counsel has had with the victim.
At which point did I make a statement on behalf
I'm
of
sorry, Mr. Lynch. I'm just letting the court know the state's concern. I would ask that if the court is inclined to have any motions hearing over the state's objection, if we can have a moment so that it is not a motion by ambush by counsel. We were not made aware of this prior.
Right.
So I would just ask for a couple of moments.
I'm gonna give y'all 10 minutes to talk about talk to whoever you need to talk to. Give me the information you need to talk to on Mr. Bowie, review his record. And then if after that 10 minutes, we'll talk about it. All right.
Thank you, Your Honor. May I have a breakout room with the victim, Ms.
You may.
Hemphill and Ms. Hagler, please?
Sure.
Thank you.
Can I just say one thing?
Sure.
At no point did I make a statement on behalf of the victim or attempt to speak from the victim. I would not do that. I don't appreciate that assertion. I said he wanted to be heard. That was what his own words on the chat. didn't make any statements on behalf or purport to represent the victim. Thank you very much.
All right, gotcha. All right, what's going on?
Yes, Your Honor. Again, the state is objecting to proceed forward without a motion being filed, but if the court is inclined to still proceed, the state is ready to proceed.
All right, Mr. Lynch, the state is entitled to have time to prepare. It's not just that they look at his record, which they have access to, but they also entitled to do some research, to talk to people. So when we get these situations, I know he's an active inmate, and I know he's entitled to have his bond reviewed if the conditions for denying him bond have disappeared, but a motion can still be filed. And so to continue to spring these on to the state and then call it judicial efficiency, I just don't think that's fair.
Judge,
Okay. I understand, like I said, I was a magistrate, so I understand 1710-1, 1761, and how bond can be denied in cases such as this. However, they are entitled to the same, I have to be fair to both sides. And so just like you're entitled to bring a motion for bond consideration on behalf of your client, they're entitled to be prepared to argue a motion for bond consideration. And so everything is not an emergency.
well, hold on. Your Honor, I understand the argument about notice, and if that's the court's decision, then that's something we'll live with. However, I'm making a motion to set a bond for my client who's entitled to a bond right now. And I would ask that if you're not inclined to hear that today, that you place it on the next jail calendar so we can be heard at that time. The state has put on notice right now that my client is seeking a bond which he is entitled to. And my client has been held in custody without bond for at least some period, into which our position is that he's entitled to a bond. Judge, I didn't know that he was.
All right, so let me ask you this. How did so it's my understanding. So if magistrate court was disinclined to set a bond based on the fact that he had a prior probation or parole, what happened with that condition? What happened with that?
His probation out of Cobb County has recently been closed, Judge, so he's not currently on probation with Cobb County.
Okay, and when was that closed?
It appears to have been yesterday because he was on a 2-year probation in Superior Court of Cobb County, March 31st of 2023. So yesterday is ended the 2 years as we're in 2025. So it was still in place when the order was signed on March the 7th, though, by Judge Parker, the bond order.
Okay. So he was denied bond on March 7th. The probation just closed yesterday, March 31st. So he wasn't entitled to a bond on misdemeanor under 1710-1 and 1761 until today, is what you're telling me.
Based on the information that I have, yes, Your Honor.
Yeah, so the condition that would have allowed him to have a bond set just went away yesterday.
Correct. But again, the defense counsel still needs to file a motion to put us on notice.
So I don't, the state keeps referencing that defense counsel filed a motion. I don't believe they're citing any
Everything okay?
That requires that.
Ms. Hemphill, you need to mute your phone, please. Mute your mic, please.
Oh, you left your money at the house, Kareem, okay?
Ms. Hemphill.
All right.
I'm making a oral motion to set a bond on his case right now. I will file the written motion today, but Judge, I need you to stop talking. Judge, I believe it's well within the power of the court to set a bond.
It is, Mr. Lynch. I'm clear what my power is. They teach us at judge school what power is. I go to the classes, I learn. But the problem is that a lot of times when we have somebody who's in a situation where I get it. I get that the default on a misdemeanor is to grant a bond. I get that. But there are also situations in which the denial of a bond on a misdemeanor is proper. And I know that too, because I was trained on that. So what I'm saying to you is the condition precedent that would have allowed the magistrate court to deny him a bond was still present until yesterday. And so what I'm saying is your emergency does not make an emergency for the state. They still get to do the due diligence necessary to weigh in on whether this person should have a bond. Yes, it's a misdemeanor. And what type of bond he should have, what type of conditions should come with that. They have to, they get the opportunity to talk to the people who witnessed whatever it was, the people who were involved in whatever it was. And so what I'm saying to you is, you would not like to be ambushed in that way when somebody rolls up on you and says, hey, we're going to do this today because, well, I'm bringing it up now, and the judge has it within her power to do. I have a lot of things within my power to do, and my job is to balance it so that I'm fair and I protect the rights, the constitutional rights of the defendants, but I also have to be fair to the state. And what I don't want to get in the habit of is just because somebody's in an orange jumpsuit, it now becomes an emergency because they had a condition that made them not eligible for bond before, but now all of a sudden they're eligible for bond, and I have to jump through hoops because now they want a bond. We're going to put this bond here and off to next week. You'll file the motion today, and we'll start doing that more often than not. Okay, because every time somebody comes up and they don't have a bond down from magistrate court, it does not make an emergency. It makes an opportunity to examine the conditions as to why in a situation where a bond is the default for a misdemeanor, why a bond has been denied. So in this case, y'all can do one of two things. You can negotiate, and now that the condition precedent for denying the bond is gone, you can send over the information and ask for a consent bond, or you can be put on the next available jail calendar, and then we can talk about a bond. And have a bond hearing, but everybody's entitled to notice. And so when you just say, well, it's in your power to do it, Judge, but how often am I supposed to just deny them the opportunity that they have to prepare?
And I understand the court's position, Judge. I also think that under the Constitution, pretrial incarceration, is to be, it's not supposed to be punitive in this case.
I'm not saying it's punitive, Mr. Lynch, but I don't know anything about the case. And what I'm asking them to do is opine as to the type of bond they would suggest, the conditions of bond would suggest, the situation having to do with, I just talked to a probationer who, in the situation she's in, she was the one convicted of the battery, but the situation looks like it may have been a domestic violence and she might have been a victim of the situation, but she asked for no violent or harassing conduct. And I'm contacting, I'm going, okay, maybe that's something that should not have been granted in that situation, because it looks like maybe she's the victim. And so I will be more intentional about hearing what I need to hear before I just modify conditions and grant bonds. That's just it. I'm entitled to have a hearing where people are prepared to argue, just like I did downstairs where I was sitting by designation as a Superior Court judge. We had a time for bond hearings for everything from murder on down, and we had the opportunity for people to prepare for those hearings. Just because it's a misdemeanor doesn't mean the state doesn't get the opportunity to prepare. Everything is not an emergency. And while I respect the fact that pretrial detention is not to be punitive, in a situation where I have to weigh whether there's likely to be another situation between these parties, then I should have the opportunity to hear from a prepared both sides. So just because I can do it doesn't mean I should. And that's the thing that comes with wearing the robe.
And Judge, you
are supposed to zealously advocate for him as your client. And I get that. And I say, do that. But the state also has a client, and they're supposed to zealously advocate for the people. And when I take from them the opportunity to be prepared in a bond here, because I'm gonna just say, well, he's coming up, and I've done it several times, but I need you to understand that that's not gonna happen every time. All right, so he's gonna be put on the next available calendar if y'all work something out between now and then. But yeah, we need to do a sooner one, Miss Val, because of the nature of the detention. But yeah, you need to file that motion today.
Sure, Judge. My client did want me to, my client contests the fact that he was still on probation, but I don't have anything to back that up.
I got that. I'm fine with that. But the whole point is the magistrate court did it right. And the condition that they used to deny him bond didn't end allegedly until yesterday. And so once that ended, file a motion, and then we'll have the bond hearing. But just because it ended yesterday, that does not make an emergency today. Okay?
Hey, you're not helping yourself right now. Judge, at this point, I understand what the court has ruled, and I'm not going to, and I don't think that I'm going to be successful in undoing that. I would just point out that you did say something I agree with. You said just because I can do something doesn't mean I should. And I would just point out that that also applies to the magistrate court when they're denying bonds every chance that they can for any little reason.
But let me explain to you how it works, because I've sat in that seat. When you have a situation where violence is the issue, where it is a battery, a simple assault, as a magistrate, you get 5 minutes to look at the paperwork and to review what a police officer has given you. And we have, as magistrates, access to the criminal file. So the GCIC, when we look at that and we see probation and parole, we don't have the opportunity to call Cobb County and say, hey, let me speak to the probation officer and let me get a full and fair and complete understanding of why he's on probation. What this is, all we know is violence, probation should have the opportunity to opine as to his ability to get out of the situation that he's in. So yeah, no, the magistrate court, when they follow those rules, they're following them to the letter because they are constrained by the fact that a first appearance hearing happens within 48 to 72 hours of the person being arrested. And sometimes it's shorter than that. So they're going on the information that they have at the time, which is appropriate. If all they have is the GCIC and the police report, and it says on their probation or parole, that is the reason 1710-1 and 1761 are in place, because at the time, their first duty is to make safe the community and the person who is the alleged victim in that case, and possibly even the defendant, to keep the peace. And they do that by looking at that. So when you say, well, just because they have the ability to deny, if they had more time, if they had somebody who was prepared to argue a bond hearing at the first appearance, then maybe they wouldn't have to do that. But that is not the mechanism we have. And so what I'm not going to let you do is just decide that the magistrate court, by exercising this legal right that they have, is wrong to do so, because they're not. The whole point is to keep the peace. And if what their indicators say is, hey, we need to slow this down so that the probation or parole officers or the judge involved in those cases can maybe get some notice that here he is, we have him, then that's what they do. Now, this may not be the case where Mr. Bowie is one of the people who their probation or parole officers have been like, okay, we've been looking for him. Thank goodness you got him. Let's slow this situation down so we can review what's going on. But that's the mechanism. And so you don't get to for somebody who's sitting in that seat and who has the limited tools of, I've only got the GCIC and I've only got what the officer has put on this thing. They don't have the opportunity to speak with somebody who's the alleged victim in that case. They don't have the opportunity to speak with somebody who is the probation or parole officer. They only have those tools. And so when you say, well, just because they can, they shouldn't, well, you're saying they know the whole situation, and they should act as if they know the whole situation when they don't. And I can confidently say it because I did it for 4 years. Okay, so now that I am in the position where I actually get to give some time to review the situation and to determine whether it is appropriate and how much of a bond it is appropriate to set, then yeah, I'd like to be able to get people to be prepared to tell me exactly what I want to know. I can run and gun if I want to, but is the right thing to do? So you zealously represent Mr. Bowie. I will continue to maintain the balance between his constitutional rights and the right of the state to defend the citizens of this county as they see fit. But just because their client is not in jail doesn't mean that they don't have the opportunity to have notice and be prepared for a hearing. Okay? And so we don't just stop every time somebody doesn't have a bond. We need a hearing right now. Not doing that. There may be some cases where it's appropriate, some cases where it's not. We clear? All right. So we're going to reset and unfortunately, I don't have another hearing date until April 15th. So if y'all work something out, that's fine with me.
I lost everything. And my son is homeless and I lost everything. My son is homeless and I lost everything.
Work it out. Because if you don't ambush somebody, then it's more than likely you can work it out. If they have the opportunity to speak with the alleged victim in the case, and they have the opportunity to look at his record, maybe talk to the parole officer or probation officer, and you tell them, hey, this condition just ended, can we work something out? That's one thing. But when you just ambush somebody and say, well, let's push through a hearing, and they're not prepared, they're less likely to work with you. But let's try that, okay? So this is my understanding that this is Mr. Bowie is entering a not guilty. I'll accept his not guilty. We'll set the bond hearing for April 15th. If y'all come up with something before then I will sign a consent. But that is it today.
Thank you, Judge.
All right. All right.
And Judge,
anything else?
I just want to say, Mom, I didn't mean to imply any malfeasance on the behalf of the magistrate court. My comment is just based on the fact that I see more often than not everyone getting denied bond in any case where
I get it, Mr. Lynch, but what I tell you is, first of all, magistrate court is the busiest, most chaotic court that you can ever serve on. And in fact, it is my honor to have served there because it made me the judge I am today. When I tell you that in magistrate court, you are hit with so much in one day. If you're on criminal, if you're on civil, if you're on intake. So every one of those days is chock full of information, cases, people, review. So when we're doing a hearing like this, and I might have 10 people on my hearing. If you're talking about magistrate court on first appearance, they can have 30 people coming in on first appearance, and they're having to review that information when they get in at 8 o'clock in the morning until the time that they have the hearing. All they have is the GCIC for each person. It is not where they get to spend hours looking at this person's history or their record and then make a decision. We're talking 10 to 15 minutes maybe per person if they have that. And so they are making the most reasoned decision that they can make. And when, somebody who has the benefit of time gets to then say, well, maybe they're saving lives. You ever think about the fact that when they're denying a bond, they may be saving a life, but we might not know it? They're doing what they're supposed to do per the law that they have before them, per the facts that they have before them, per the time that they have to deal with the situation before a whole new crop of people come in for the next 24 to 72 hours where they have to have a first appearance hearing in that period of time. And we're not just talking about misdemeanors, we're talking about major felonies. They see everything. Like I said, from murder on down to ordinance violations. And so when you're talking about judges who deal with that volume of cases, who deal with those levels of cases, and they're able to make distinctions, they're able to put cases where they need to be. If it's a felony and they see that it should be downgraded, they're able to do that. If it's a misdemeanor and they think it should be upgraded, they're able to review that and do that. You can't impugn the ability of the magistrate court and those judges to do what needs to be done in the short amount of time that they do it. So when they err towards keeping people safe and keeping the peace, I can't fault them for that. All right. So that's all I got. Talk to y'all later.
You know, the few times I get excited from editing is whenever I got to be able to put this guy in black and white. It just made me happy to see him just depressed there. Yeah, I guess it's good to have someone else feel the same way as me sometimes. Now, me and Fozzie was talking about this a little bit earlier, and Fozzie was just, expressing, how odd it was that Judge Fleischer is always willing to talk bond and Judge Tammy was not, and I quickly defended her because that's what I'm going to do for Judge Tammy. But I get what he's saying here now. I kind of feel like there's a reason why she did that, but I also feel that, everyone has a right to a bond, so, yeah, I don't know. Kelly's saying she's 60 years old. If she's 60, she's doing damn great for 60. I'm surprised there. Let's go to some kids taking their internet drama to court. Of course, it's Thurston County where Petty wins. No, Fletcher boy, he's not getting out of jail. He doesn't even have a bond. So he went to jail on a probation violation, and that's been dropped. And so he has the right to a bond for the new charge. And so the magistrate denied the bond because he had a probation violation, but they dismissed that. So kind of the underlying thing is it's like going to jail for a DUI, and then they realize that no, you were just diabetic, and then still keeping you in jail anyways, even though they realized that you weren't drunk. So I don't get it. So, and it's true there. The state needs time to go over. So you know what? There's an easy way of doing that. Just don't get yourself caught up in jail, and you don't have to worry about timelines like that. So we'll go over here to Thurston County.
All right. Just want to be sure you're still with me, because you can tell me. Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, so give me a moment just to get the documents and petition and so forth up before me. So let's see, there was a temporary restraining order issued against Ms. Paris, protecting Ms. Carnes. And that's what we're going to talk about today, whether that continues after today. So Ms. Carnes, are you still asking the court for this order?
I read Molly's statement where she said that she has no interest in ever contacting me again, which is honestly really all I want. But I think I would feel more safe if we just had this just kind of like as an insurance, kind of like, because I am worried that like she may not stick to that.
Well, Ms. Paris, do you object to this order issuing?
Yeah, it's just a little silly.
Then let's have a hearing. And I'll start out with Ms. Carnes and know from both of you. Let me just, I've had a lot of hearings and I want to re-review what we had here so that I know where I'm coming from. And then I'll turn to Ms. Carnes first, and I'll hear from Ms. Paris. And all right.
In July of 2023, and it's just been kind of a constant stalking of my profiles.
When you say that, what does that mean to you?
So it was like multiple times a day I would get a notification that her username viewed my profile on TikTok. She would message me. I was also under the impression.
Let me step you back though. On TikTok, I mean, that's out in the public domain and you expect people to look at that. How is that stalking in your sense?
Because she would message me about my videos, accusing me that it was about her partner, which is my ex-fiance.
So a message would occur after you saw that she accessed your TikTok, then you get the message, and the message would say that, that's what I'm trying to figure out. So
just kind of that he really just thinks that I really am interested in being with my ex Chandler, which I have honestly, I have no interest in speaking to them again, either of them. I just, I hate that I had to make every single one of my profiles private just so that I could live my life without having to worry that like I'm being watched. Because that's like such an unsafe feeling. When I
all right, so then so the messages were that something about an ex.
Yeah, and then there was times when there was threats, which I submitted one of them.
Yeah, the one that you talked about back in November, is that what you're talking about? Being threatened to knock my teeth down my throat after I called her out for once again stalking my profile. So that goes back to November 2nd.
Yeah.
Okay, so that was, you had noticed she visited one of your TikTok or what? And then
I was hanging out with her partner when they were split up. Me and her partner had become friends again. And she was very worried because she loves them and she wants to be with them. And so like, felt a little insecure and took it out on me when the second that I was told like I wasn't wanted around, I left. I blocked on everything. I was like, okay, cool. This is my escape finally, because this has been multiple years now of a very toxic, abusive situation that I just don't want to be a part of it.
Jump you back. So November 2nd, you get that, and you didn't come ask for an order. 5 months later, you come for an order. So what did you think that statement meant at that point, threatening to knock your teeth out?
Well, to be honest, I understand where Molly's coming from because I also used to be very protective over Chandler. And so like the thing that made me worried was Chandler and Chandler's family warning me about Molly and all of like telling me that she was a scary person. But I figured that like, I had Chandler around at that time and I thought, I would be okay. And I'm also just used to rolling over, especially in this dynamic relationship. It's just very messy. And I think I just figured I would let it, and we talked it through was the thing. And we both realized that we were being lied to about things because I was told she was an abuser, like we talked it through. So that's why I didn't report anything.
Okay. And so after that November threat, and then you talked things through with Ms. Paris.
Yeah. And I thought we were okay.
All right. That's good. And then after that, the thing that got you to come to court was
then all of a sudden, I got a call from my friend who was in town. I see her twice a year. She was at Buffalo Wild Wings. She wanted me to come, which is like just a few minutes down the road from me, right? So I drove there to go meet her because I feel like as the victim of abuse, I can decide if I feel comfortable going to a restaurant that my abusive ex is a cook at. I wasn't planning on seeing her. I thought she would be in the back cooking. And I didn't speak to her at all. However, a few days later, I then received a message from Molly, which I submitted about going to that restaurant. And like, I just, then it was another message and then another message. And it was just happened to be one of the like profiles that I forgot to block when I went through my block list, and it was all in my message requests. And then I didn't respond. And she then said in one of the messages, like, you should have fucking responded to the first message, because now I'm gonna tell the whole 9 yards or something like that. I'm sure you have the picture in front of you. But
so you added 3 images. You added 3 images to your petition, and it's nearly impossible for you to know when these happened and who writes what. So
okay.
Maybe
I'm sorry. I thought I had I know the first time I sent in stuff, things were corrupted, so things might not have fully been sent through the second time.
So they just say, 123 and 128 and time and sluggy lady, and I can't determine who's
lady is Molly's account.
Okay.
And so that's a screenshot of my message request on Instagram, because I don't have her added on there, but I did forget to block. And so then all of a sudden, and I didn't even notice the messages at first, because like I said, they're in my requests, so I didn't see them right away. But when I realized that, because I haven't spoken to any of them since December, so I just figured clean cut, never have to deal with it again. And then all of a sudden I'm receiving message after message, and she's viewing all my stories again. And I'm scared of getting pulled back into that toxicity, and from messages from the ex and her current partner, and messages from her herself saying that she gets violent and abusive when she drinks. It scares me.
Did you ever see that when you knew her?
I did not, because I've only ever seen her twice in person. I've never really interacted much with her in person. I mostly just know of her through stories from Chandler, which was a year and a half of a story of Molly abusing her. And so I don't know what's true and what's not. And so that's why I just figured, and I'm not the type of person, I just wanted to let it blow over. But I had my therapist and my care coordinator and all of my friends that have been watching this go on for years just finally just be like, you have to do something. So I am.
Right. Okay. All right. And anything that you wanted to comment on what was filed by Ms. Paris?
Just the idea that it's a retaliation. It's really not. If it was, I would have, gone with the years of abuse evidence that I have on my phone against her partner if it was retaliation. And I'm not doing that because I just want this to be over. But I also really respect the fact that Molly's willing to not reach out to me again. And because that's at the end of the day what I want, because in a way, it's I know that me going to the restaurant her partner works at upset her clearly. But for me, I feel like it's better to face the devil than the one you don't. So I know how Chandler hits. I don't know how Molly does, but I've heard stories, and that just scares me. And I just think that like I want out fully, and I just want to move forward with my life, and I can't do that if every move I'm making on social media is being stalked. It makes me paranoid. And I don't want to live that way anymore. There's a reason that I have walked away. There's a reason I moved homes. You know, like I want to leave for real, which includes having my ex's girlfriend leave me alone. But I appreciate the response, and I understand why Molly might think some of the things that she does, but I just want out, and I don't want to get hurt in the process.
All right, so, Ms. Paris, then you did file a 4-page response, and I appreciate that. It's always helpful to have things put to writing. And I've had an opportunity to look at that before court, and again, re-reviewing things on the right page here. Anything else, Ms. Paris?
Yes, I would like to say there has been contact between Miranda and Chandler's mother, Chandler herself, and she has reached out to both of Chandler's siblings who are younger than us and definitely younger than her. And she has been let know. Chandler had explained to her after everything that has happened.
I don't want to hear anyone talking to me about what Chandler is saying.
It is because
not of issue.
Miranda has been let know that I was misrepresented. So I do think it's interesting that she's continuing to bring up the fact that she's heard stories. Chandler has a year and a half of this, but it's within the last few months, like at the beginning of everything, Chandler reached out and was like, hey, by the way, I did make up like all of that. So I'm not going to keep disrespecting Molly and choosing to hang out with you because it wasn't fair that I treated her like that, basically. And also mainly just this whole concept of that I have been continually messaging her and stalking her. I cannot comment on anything from the July stuff because I honestly don't remember at all. But what I do have is the messages on TikTok, because the whole reason I had reached out onto her TikTok account, besides looking, because it's social media, she saw that I viewed her account, and then she had made a post on her story saying like, I see you, bitch, you mad? And so I replied, and I was like, oh, no, I'm not. Blah, blah, blah. And that's where you see the ones from me threatening her the first time on November 2nd. And I don't understand where she's gathering this idea that she's in danger if she's continually reaching out to me, which is shown in the first exhibit where she came to
exhibits
or
your exhibits.
My exhibits.
Yeah.
So exhibit A, I guess. And this is also why I wanted to argue at least the drug assessment.
These are from December 11, right?
Yep.
Okay.
And the threat happened on November 2nd. We became friends basically that day after finding out that we were both getting lied to. And she wanted all three of us to be friends. She came to pick up drugs from my place of residence, which is why I think it's funny that she's filing for a drug assessment and talking about my
this court
drinking.
isn't going to be ordering anything like that. No matter what I do, we don't have that authority. So, but this is evidence then that you've been having this.
We've been having a situation where she wants to hang out, and the last contact that I have of her is from December 23rd. That's this exhibit B, where she is asking to come hang out with me and Chandler to go to a karaoke bar, I think it was.
And then, all right, what's your exhibit C? I can't quite figure out.
This was proof of
talking to
her
who.
coming to Chandler's workplace. And the reason that was like, yeah, cool, you can go where people work, I guess. She has been well aware of Chandler's scheduled days and what Buffalo Wild Wings, where it is, you know, she's going to be there. And she's not just a cook, she's a server now. And Miranda would be in like knowledge of that because they were hanging out when that started. And this basically is just a retaliatory thing because the only reason this was filed when she was referring to her exhibit of the like me saying she should have responded, it was because I have been continuing to find out information that she has been talking about to like multiple people. I found out that her mother has found out about like my addictions past and like homelessness and things like that. And she has continued to make posts about me, but it is an indirect, so technically it could not be, but talking about how at least I know my ex is crazy on the day that Chandler let her know she didn't want to hang out anymore. And it kind of just seems like she's mad she didn't get the last laugh type of thing whenever Chandler stops talking to her, because that's when, around that time is when she petitioned this and then went through and deleted all of the posts she had made, which kind of like shows she knows that posts aren't going to line up with actions type of thing. Yeah, it's just a little silly.
All right, so your point here is that that there isn't a basis to find, if tell me if I'm wrong, there's not a basis to find that you're intending to commit unlawful harassment.
Exactly. Because I have never been asked to stop contacting her. I went through every message that I have on my phone given. I cannot talk about July. I don't have any of that. There has never been a Molly, you need to stop contacting me. I've gotten her being antagonizing on the story and then wanting to be my best friend for a while. And then once she had stopped talking to Chandler because Chandler cut it off, that was the day she also cut me off. So it's kind of like she was, yeah, this is just silly, basically. There's no harassment. I look at Instagram or TikTok, I apologize. It's been public up until literally 3 days ago. So it seems like she's she has not been putting forth the effort to make it known that I'm scaring her or making her feel paranoid or harassed. So this was just a bit silly, in my opinion.
Yeah. So Ms. Carnes, I'm not issuing an order against this. I don't find it silly. You know, that's up to Ms. Paris to decide how she feels about it. But there just isn't, and I have to find, is there an intent on Ms. Paris to commit unlawful harassment against you, all of her actions specifically to cause you emotional distress and actually causing it and having no lawful or legitimate purpose for it. I can't find what the law defines as unlawful harassment. So there will be the order ends. There will be no further order going forward. I think the two of you have made it clear to each other you're not real interested in having any contact. So I suggest that you go along those lines. And so that's it for today. I'll write an order that ends the matter. And that's in the file. So
well, thank you so much.
The two of you.
Have a great day.
Thank you, Your Honor.
So long. So are you here for a 130 case? Who's here for court?
Okay, good. I'll jump in. This thing still had 2 minutes left of it, and I was like, I couldn't figure out what in the world was left on the last 2 minutes, but it's just called bad editing. All right, everybody, that's all I had in me. Yeah, it's 6 o'clock. It's time to go back to bed. We will catch you guys later. We'll try to do another live or so, but Kathy's going to do a members only at 9. So if for some reason you're not a member already, today is your opportunity to jump on that. Get in there, get a membership, and come check her out at 9. She's got something going on. We are going to get out of here. It's way too late or way too early. I'm not sure which. You guys have a great morning.